People versus Codie Hayward.
I'd like to reserve 3 minutes for rebuttal, please.
Yes.
Good afternoon, Your Honors. May it please the Court, Kristen Bluvis from the Rural Law Center on behalf of the defendant, Codie Hayward. I'd like to first start by talking about the history of no-knock warrants and what they authorize the government to do.
Before you get to that, on that issue, can you address whether that issue that divided the majority and the dissent in the appellate division below, is that a mixed question of law and fact? Is that a different factual interpretation of the record that we're not going to be able to address?
I would argue that this court can find ineffective assistance as a matter of law, and they can decide this issue as it has been presented to them.
Well, to do that, would we have to determine that there was no support for the majority's view that this was not a no-knock warrant? I mean, that they didn't break the door down?
You asked what was there.
I had too many negatives in that question.
Yes, sorry.
To be able to disagree with the appellate division majority, which said essentially they didn't break the door down, would we have to conclude that there is no evidence of that nature in the record?
I think that to be able to disagree with them, you would have to conclude that that was incredible as a matter of law, that given this record, that there was enough, given the police report, given the police testimony, that it was incredible as a matter of law to conclude that a no-knock warrant did not occur.
Is that particularly difficult for us to do here because it's unpreserved, so the people didn't litigate it? So if you had raised this issue in the suppression court, we'd have a much better record.
It is difficult. I do agree with you. However, and then if we step back at the context it's raised in context of ineffective assistance of counsel, the reason that we don't have a sufficient record, I argue, is because counsel did not, see this very clear issue that the warrant was exceeded in the scope.
Is this a single issue error with respect to counsel?
I would argue that it is because it would be dispositive.
And was the law clear with respect to the issue itself and what was the law clear that if it was violated, what the consequences were?
So this court has not considered that issue, but I think, even though the Supreme Court in Hudson has said that it's not, suppression isn't always required, it has also said the opposite, that, in federal drug raids, it's...
So they've said it's not always required, so that's the floor, and we haven't decided that it does require suppression. So how can that be enough here to get the relief you're seeking?
Well, I would argue that that counsel's failure to raise that is what was the issue. Like, this was not, challenging the scope of a warrant is very routine defense practice. There was no reason for them not to
maybe
do
he
that.
read Hudson and decided, he or she, that it wasn't worth raising. And are we to find that, based on Supreme Court precedent, a decision like that is ineffective?
I think, you have Hudson, but you also have, Richard v. Wisconsin that makes the opposite point, that there is no per se rule on the
But doesn't
other
the
side.
issue have to be clear-cut and dispositive? Wouldn't the success of that motion have to be basically a foregone conclusion?
I don't think we have to prove that he would have won that, but I think we have to show, that there was no objectively reasonable strategy to not challenge the warrant. There was no negatives to the defendant for him challenging the warrant.
In addition to Hudson, don't you have to deal with Rodriguez, which suggests that for technical violations, I know that was a nighttime issue, but that suppression isn't appropriate. So I think we would have to conclude that even though we might view a nighttime constraint as technical, that we wouldn't view knock versus no knock, and maybe in a context where a no knock warrant would have been available given the circumstances. So what do you do about Rodriguez?
And I think they're distinguishable. This is not a technical violation, and it's something you can look at in Hudson.
But is it clear cut, to go back to Judge Canataro's question about the standard here for ineffective assistance, how would we find it's clear cut in light of Rodriguez? That's what I'm grappling with.
I think you could find that it was a clear-cut issue to challenge the scope of the warrant at a minimum. That would be, that it was defective performance as a
So are you
matter of law.
suggesting that regardless of the state of the law, it was a claim that any competent lawyer would simply raise? Is that what you're arguing?
I'm arguing that, defense counsel should have raised this issue. It is routine practice. If looking at the omnibus motion, it was clearly done from a template, it references other defendants' crimes.
So again, regardless of the state of the law, it's something that routinely a competent lawyer would have simply raised.
Correct, yes.
Well, but even when you're raising, sort of routinely, this is something that you would file a motion on, it can't be frivolous. Legal basis for even a routine application. You agree with me there?
Correct.
Okay,
but there
so why is it
was-
not frivolous? Is it because it's novel under the state constitution? We haven't resolved that question. The questions you're being asked make it clear we haven't resolved it.
Correct. It is novel, but it is also, not decided at the federal level. There's no per se rule either way. It would get the defendant to evaluating the reasonableness.
Let's say we disagree with your argument here, and we disagree with the dissenters, and this is really about the state constitution.
Then what is your question? I'm sorry.
Well, in a more, I guess, direct way, is a counsel ineffective if they fail to raise what is obviously a novel claim? One novel in that sense that has not been resolved by the Court of Appeals that would be dispositive in the case, or at least would severely weaken the prosecution.
I do think that counsel is defective in this case. He wouldn't always be defective for raising a novel issue while the search discussion is something that may be up for dispute. Challenging the scope of a warrant is not something that's up for dispute.
Can you just clarify what you mean by that, the scope of the warrant?
Well, their authority was granted by the warrant, and their authority was not given to the extent to conduct a no-knock raid on this defendant's apartments. And we don't know what the magistrate would have done if this was requested. It was, a multi-level apartment building. While there were drugs that, could readily be destroyed, there could have been many other considerations. And by not putting that before the magistrate, I would argue that we have to look at the search at the point of when it was conducted, and in this case,
And
it's
do you think this
unreasonable.
record is clear about what happened upon entry or right before entry for us to come to a determination?
I do think there is enough on this record. While there could be more, I think you have the officer testimony. I think the after-action report, from the emergency response team is very detailed. It's very clear as to what the officers did prior to the entry, how they moved themselves into place secretly, how they, the different equipment that they brought with them. 23 officers, 17 handguns,
But they
shotguns.
could have done all of that and still, before they touched the door, have said police, right? Or whatever they're going to say, warn that law enforcement is going to come in if you don't open this door.
I think it would be illogical to conclude that they.
It would be what, I'm sorry?
Illogical to
Illogical.
conclude that if they gave that detailed report of what they did to omit that information. There was quotes of what they stated as they entered.
Whose report was that?
It was an after-action report by the police department that's prepared routinely, as a matter
I
of
guess
business.
I'm asking because I know there was an issue raised as to whether or not all the officers would have been in a position to know or to have heard whether an appropriate warning was given.
And that report informs on that issue. It explains which officers entered first, which were in the stack behind the which conducted the battering ram, which held the shield.
And how does that address whether or not indeed there was a prior warning?
How does that-
Knowing the order of those who enter, knowing who's carrying whatever they're carrying.
Right, those officers, the officers that we primarily rely on, Pedrick and Blowers, were the first officers to enter. They are going to have the first impressions. They were, the ones that were yelling, and Officer Pedrick, as he entered, yelled, "Police, search warrant." If he had said that before, he was the one designated to do that, that would be in the report, I would argue. I'd like to just touch briefly on what the remedy in this case is, and that I think that the remedy is suppression. If this court can find as a matter of law that counsel's performance was defective, that suppression can be ordered. While I think there still is enough, we also would request that this could be sent back to county court for a hearing because of the colorable claim of a violation by the defendant, or on behalf of the
Let's say we agreed with you. Would the prosecution have the opportunity to now establish that indeed there was a warning in advance, that this was not a no-knock search and seizure?
Well, the
Or warrant,
officers
yeah.
could be called back and ask that directly. I don't know what they would say. That wasn't actually asked of them directly. It could be contradicted by the report that they issued, and there would be credibility issues as to why that wasn't included in that report, but we don't know. Thank you.
Thank you.
May it please the court, my name is Bridget Rahely Steller. I'm an attorney with the New York Prosecutors Training Institute, here as of counsel to Fulton County District Attorney Michael Poland.
Can you address that issue about the state of the record, and if we have enough information in front of us about the nature of the no-knock or the announcement, and particularly that report? Does that shed any light?
Your Honor, I don't think the record is sufficient for anything, and I have a couple of issues here. First of all, if you look at CPL 71060, you're supposed to make a suppression motion prior to trial, or you're supposed to put all your grounds in your suppression motion, and that's the exclusive means of deciding that motion under, it's the first, CPL 71060 refers to CPL 71020. And the first thing in 71020 is a personal property, suppression of personal property. So this issue should have been raised, if it was going to be raised, should have been raised in the omnibus motion and motion to suppress. That's where you would have had a hearing on, was there,
But that's counsel's point, that the trial counsel, excuse me, was ineffective. So what happens when you have that scenario?
I don't think you can say this attorney is ineffective based on this record, because you don't know what he knew at the time he made the motion, and if the only time he hears about this delayed or maybe simultaneous announcement is during trial, the issues you're deciding at trial are, is there sufficient evidence that this defendant,
Was the law
Wouldn't you-
clear?
excuse me?
Wouldn't you expect, when you look at both the testimony and the after-action report, that if in fact one of the officers had knocked and announced, that they would have indicated that in the course of their testimony? It's pretty
I think,
thorough and detailed. Why wouldn't that not be in there?
well, number one, I don't know how you get an after-action report in there without going through who wrote it and what their basis of knowledge is.
Okay, but in terms of the recounting of what happened,
Go to the two officers who did testify. Sergeant Pedrick says he was supposed to be the first person on the battering ram. And he says that as they went through, they announced police. But then he also says,
right, and so just to stay on that for a minute, he does say that, and so seems to me that if he had also announced that he was there before he went in with the ram, that he would have said that in the course of his,
But he was never asked that
testimony.
question, and what becomes even more important is, I think if you look at, I think it's A110 in the record, he testified, as we approached the rear apartment door of 3W, another officer had breached the door, and the door popped open, so he wasn't the guy who was going in first. Somebody else was ahead of him. So this was never completely vetted on this record.
So you're suggesting that even, assuming for one moment, that because he didn't put it in the report and doesn't testify to it, that he didn't say it, that because from another door, someone else is in front of him, that person may have issued the warning. Is that, or am I misunderstanding?
Anybody could have
And-
issued the warning.
okay.
And also, you're talking about, even if you look at Sergeant Pedrick's testimony, it's almost simultaneous. And if you look at, even if you don't have the no-knock authorization, you have to knock before you enter and announce, but there's no specification about how long you have to wait before you both break the door down. Could be 10 seconds, it could be 5 seconds, it could be 30 seconds, it could be 20 minutes. So there's no specific requirement as to how long you have to wait. So you can't really tell from this record because they're talking about it happening at once. And
With respect to the claim, assume for the sake of argument
Yes, Judge.
that there is a record to say that the no-knock was violated. Was the law clear that suppression would be granted?
No, Your Honor, and that would be my second point, that in order for you to have a valid argument that the defense attorney was ineffective, it seems to me that there has to be a clear law that any reasonable defense attorney would have raised this issue. And if you look at the state of the law,
So
You had-
you're saying, if a lawyer is aware of a novel issue not resolved by this court, and they choose not to raise it,
yes,
that any other defense lawyer would have raised, they're not ineffective because it's novel?
well, I think it's novel, but I don't think you can say here that any other defense attorney would have raised this issue. But again, you go
Why
back
not?
to.
Why not? Why not? Would have been, if they would have won on the issue and gotten a remedy, all that evidence is suppressed. Then you're left, I believe, you correct me, you're left with the CI's statement, and that's it.
But if you look at it, and you see, number one, I go back to, what did the attorney know when he made a suppression motion? Then you make strategic decisions. And if he didn't know, or if he knew something else that it had in fact happened, he
No,
wouldn't
but
be making
it was
this
a different
motion.
hypothetical. I thought Judge Troutman had said, let's assume for one moment that there's no ambiguity in the record, there's no uncertainty, that's not what the dispute is, everyone agrees they did not give the warning up front. Okay?
Okay.
All right?
I still-
And everyone here, of course, agrees that the lawyer never raised such a claim.
I still think that since the issue had never been decided by this court or by any of the intermediate
But that's the
appellate courts in
point.
the state.
That's the point. It's not
And-
foreclosed because it's a novel issue under the state constitution.
Under the state constitution, yes, but since you have the Supreme Court decision in there, and no other courts in this state, at least when I looked, I couldn't find anything where another court in this state had adopted or rejected that proposal, I think that the attorneys would not be required to raise that. And again, it's a strategic decision on the part of the attorney. And I think if he thought he had a better argument, and I think he could have thought he had a better argument here, because he's arguing that the whole thing should have been suppressed. On the other hand,
Are they
if he had
mutually
raised-
exclusive?
Excuse me, he
Are
did
the
lose
arguments
that. He-
mutually
he did.
exclusive?
He did, but the other side of
No,
that
no,
is.
no. Are the arguments mutually exclusive? You said he had a better argument. What,
Well,
would
that
it
might
have
been the
undermined
better
his argument?
But the other thing we don't know about is he concerned about if he does raise this argument, are we going to have a standing objection? And then he's going to have to litigate standing. Because the evidence also tended to indicate that the defendant claimed his apartment was not this one, it was the one across the hall. So you would have had to worry about, are you going to win on the standing point? So I think it's legitimate for an attorney to look at what he or she knows at the time they're making their motions, at the time they're litigating something. And you can't tell from this record what the attorney did or didn't know. But I also believe that no attorney in this state is going to be required in order to be competent to raise a novel issue.
It's not to be competent, it's whether or not the defendant is denied meaningful representation, given the error, if it is an error.
And what I'm saying is I don't believe it's an error when it is not any kind of a settled issue. And I also think that if it were a settled issue, we'd be seeing this argued a lot more in this state. Or if it was something that somebody thought they would have a chance of winning on, it would be, have been
Well,
argued.
one would hope law enforcement is not, as a matter of course, violating the statute and engaging in these no-knock warrants. One would hope.
I mean, I understand that this is a problem, but on this record, you can't even tell that. And if you look at, there's two police officers who testified here. Hedrick, who was the first one. Officer Blower, when he's asked, how did you enter apartment 3W? He says, I don't know. And then he has to be refocused. He's also the one who testifies that after they got in there were 3 people in the apartment when we know there were 4 because there were 4 arrests. So this is all credibility issues also involved here. But I would suggest to you that this is not properly before you. It wasn't preserved, and there's no showing that this attorney did not provide meaningful representation. Does the court have any other questions you would like me to address?
No, thank you.
Okay, thank you very much. We'd ask that you affirm the third department.
Thank you.
Just quickly, in rebuttal, we do know when counsel got the report that would have made this clear, it was pre-discovery reforms, so it was disclosed as Rosario, immediately before trial. It was redacted, so counsel didn't get a copy until the day of jury selection, and I submit that it was ineffective for him not to, at that time, move to reopen the map hearing when the issue became very apparent on the record. In response to the officer's testimony, while, Officer Pedrick was the second one the person that breached the door is first and popped the door open, but he was the first one in the stack of officers behind the shield. So he was the first to observe the,
Do you want to take a moment to address the Molyneux issue?
yes, and I would like to take a moment to address the Molyneux issue because that was a preserved issue, so it's a cleaner issue for the court to address. This prior sale, I think County Court was correct in their original discussion of excluding it. The sale was simultaneous. It could have been indicted at the same time. It could have been before the court. Its purpose was to show propensity, and the best evidence of the prejudice to the defendant is that the jury acquitted him of the charges for the cocaine, which was found in the same room as him with the drug paraphernalia, and convicted on the heroin, which was in a back bedroom, and the possession was the real issue at trial. So this Molyneux evidence was not relevant to his possession of that heroin. It was only, highly prejudicial, and it was the only purpose it was introduced, I argue, was for propensity, that he sold heroin.
So are you arguing the trial court abused his or her discretion?
I think that that it was an abuse of discretion to reverse their decision, because originally they decided that that they were precluded from using that, and they could only elicit, an ongoing drug investigation was occurring at the residence, and that's how the search warrant was obtained.
You mean that the trial court reversed its own
It
decision?
reversed its own decision, correct. If there's no other questions on that, I would rest on my briefs and ask the court first.
Thank you.